The construction industry is a complex and competitive environment in which participants with different views, talents, and level of knowledge of the construction process work together. In this complex environment, participants from various professions each have their own goals and each expects to make the most of their own benefits. In the construction industry, conflicts are inevitable. If conflicts are not well managed, they quickly turn into disputes. Disputes are one of the main factors which prevent the successful completion of the construction project. These disputes need to be well managed in order to complete the construction project in the desired time, budget, and quality. These disputes are caused by owner related, contractor related, design related, contract related, human behavior related, project related, external factors. Design related causes can result from a variety of inaccuracies or lack of care. This includes design errors, incomplete specifications, and quality of design. Contract related causes are predominantly management related and include ambiguities in contracts, risk allocation, and different interpretations of the contract. Human behavior causes are often much more difficult to manage due to where they originate from. These often include cultural clashes and lack of communication or team spirit. Project related causes include site conditions or unforeseen changes at the site have the ability to bring down an entire project. External factors don't often bring the project down, but should be noted. These include the weather, legal factors, or economic factors. Effective dispute resolution should aim to resolve matters at an early stage. Employees will likely be more cooperative and productive if they know that their grievances will be taken seriously by the employer. The Fair Work Act 2009 requires that all modern awards include a term which sets out a procedure for resolving disputes between employers and employees about any matter arising under the modern award and the national employment standards. Generally, the clause will provide a process with the following stages. The first step to the resolution procedure is to discuss. The discussion is usually through the contract administrator and allows them to make a decision. In the contract, it will also mention whether the decisions are binding, as most decisions can be overturned in court proceedings unless the contract states otherwise as being conclusive. Another way of resolving construction disputes is by holding negotiations in the form of mediation. It is one of the most tried methods and most successful too. Mediations are quite simple and can be done over the telephone, by email, or letters at a meeting. Adjudication involves an adjudicator to make a binding decision. The adjudicator has 28 days to make his or her decision from the start of the adjudication. The adjudicator has to be impartial at all times and must aim at obtaining a decision as soon as possible so that the work can continue. Arbitration is a form of resolution and demands immediate settlement of the situation. Whenever there is a genuine dispute between the parties in court proceedings, arbitration will be considered. It is imperative for an arbitrator to act fair at all times. Litigation is the final method of resolution. At such an instance, the case will be presented at the courts and the problem. The court will order for the disclosure of documents and witnesses and enforcing decisions with the extensive powers it has. Homeowners agreed to variations which included $2,630 for non-standard balustrades. The owners found balustrades to be different to the originals and therefore lodged an application to the tribunal seeking a refund for variations. The court found in favour of the homeowners as the builders breached the Home Building Act of 1989. The builder was engaged to knock down and rebuild the bathroom for $22,000. It was agreed to be paid in two stages, however, halfway through, the builder demanded payment for stage two, even though construction was not complete. The builder ceased work. The tribunal found for works not to be completed in time, and the homeowner was entitled to recover damages.